Okay, I think I said this in the last part, that state courts have specialty or lower courts, such as domestic relations courts or divorce courts, drug courts, bankruptcy courts, and juvenile courts. State courts also include probate courts that handle wills and estate distribution. In terms of state courts, the main thing you need to remember is that trial courts adjudicate and appellate courts interpret the law according to the Constitution. There are a series of problems the court faces today, including how to handle over 100 million new cases every year, increasing populations in some areas, more complex laws, and more civil litigation. Okay, so this next slide lists the rights of the accused in a criminal trial. Speedy trial, jury trial, free from double jeopardy, legal counsel, competent at trial, right to confront witnesses, right to press coverage, but not always, and televising criminal trials, but of course not always. Any of these can be withdrawn depending upon whether or not the judge feels there are adequate reasons for public safety or something of that nature. Okay, there's been a lot of criticism about our court system. It's important to remember that our court system is adversarial. The adversaries are not the victim and the accused, but rather the state and the accused. One of the reasons due process is so important is because of the imbalance of power between the state and one individual. Our system is not based on agreeing to a solution. It's not based on the relationship between individuals, and it's unfortunately not based on equitable resolutions. It is based on who presents the strongest case, who can convince the jury or the judge of the guilt or innocence of the accused individual. Okay, so how does a person get to trial? Well, first there's initial contact. Usually someone reports the crime has been committed. Then there's an investigation, and if there's enough evidence, an arrest is made. The suspect is taken into custody, and the evidence goes to the prosecutor. The prosecutor can file a complaint, an information, or bill of indictment, with the court having jurisdiction over the case. Complaints are used for misdemeanors. Information and indictments are used for felonies. Each is a charging document asking the court to bring a case forward to be tried. Arraignment is next. This is when the accused is informed of the formal charges, advised of his or her rights, and enters a plea. If it is decided that the case should go to trial, bail is set and the accused is either released or detained depending upon the ability to pay bail and past record and the risk of leaving the jurisdiction. Okay, hold on here just a minute. Initially I had several other things I wanted to include in this lecture, but summer goes so fast, so we'll skip those for now. But I teach those in another class, so if you take another class with me again, you'll get that information. Okay, so let's move to the actors in the judiciary process, and they are the prosecutor, the defense attorney, or public defender, judge, and jury. I suspect most of you are quite familiar with these from watching Law and Order on television. The prosecutor is the state or fed's representative and is arguably the most important player in the court drama. The prosecutor, let's move on. The prosecutor represents the state. There are federal prosecutors, generally U.S. attorneys general or U.S. attorneys. The state has district attorney, county attorney, commonwealth attorney, and state's attorney, etc. The prosecutor investigates the law violation, cooperates with the police, determines charges, represents the state or federal government in pretrial hearings and motions, makes plea bargains, tries criminal cases, recommends sentencing at the completion of the trial, represents the government at appeals, conducts special investigations to seek indictments for serious crimes considered important to the public interest, such as insider trading and human trafficking. Next, we have the defense attorney or public defender in the case of accused individuals who do not have means to hire their own attorney. The defense attorney represents the defendant in all pretrial negotiations, including plea bargaining, represents the defendant during the trial, and determines the basis of appeal. There are 3 ways communities appoint a defense attorney when the defendant is indigent. In larger communities, there are public defenders who are paid full-time or part-time attorneys, and they're paid by nonprofit organizations, the government, or other public organizations. In smaller communities, attorneys for the defense can be appointed by the judge on a case-by-case basis. Alternatively, non-salaried attorneys can be hired on contract to provide court-appointed representation. Okay. The judge rules on matters of due process and decides guilt or innocent when a jury trial is waived. This is called a bench trial. The judge also generally sentences the offender, although sometimes there's a jury. The jury sentences the offender, and sometimes there can be a separate jury that sentences the offender. Okay, before we move on to, jury, bench trial, I mentioned that, and then jury selection. The pool of people that the jury is picked from is called a venire, and the actual jury that's chosen is called the voir dire. They can be removed for cause. For instance, if the juror knows the defendant, there can be preemptory challenges by either the prosecutor and the defense, and hopefully we have impartial juries. Okay, and